All right, I had said it before, and I had made videos about Mr. Jefferson Beauregard Sessions. I made videos during his Senate confirmation hearings, and I made videos subsequent to that, i.e., for all of you weed smokers out there, he's coming to get you. Now, this particular video is basically just a confirmation that Mr. Jefferson Beauregard Sessions lied, misinformed, obfuscated. He just straight out misrepresented himself when he had his Senate confirmation hearing. Okay, he tried to present himself as this giant civil rights attorney for the Department of Justice when he was an attorney down in Alabama, and then tried to tout his record as a senator about all of the great civil rights things that he did. Well, check this out, folks. Mr. Jefferson Beauregard Sessions is now withdrawing from the lawsuit that the Justice Department had against the state of Texas in its voter ID, i.e. voter suppression laws. And we all knew it was just a question of time. Black folks, y'all should have gotten your asses out there to vote. And I mean in big numbers, because people like Jeff Sessions, you saw them coming. Now, you might not have seen Betsy DeVos coming, and you might not have seen Steve Bannon, or actually you did see Steve Bannon, Steve Mnuchin. You might not have seen Rex Tillerson. You might not have seen a bunch of these guys that Trump has put in place. But Jefferson Beauregard Sessions was there from the beginning. And if you did any research on this guy, you would have known that he was going to be black folks' worst nightmare as far as advocating for our rights. Now, you should have also realized that if Trump got in there and he maintained control of the Senate, that you were going to be screwed as far as a progressive Supreme Court justice was concerned. But all that being said, your number one deal should have been, well, you know something, I'm taking that back. Your number one deal should have been that Supreme Court justice. But number 1A should have been not allowing Jeff Sessions anywhere near the Department of Justice. But, you know, I'll say you live and learn, but in order to live and learn, you have to have some basic intelligence and do some research. And if you don't have either one or both, you know, this is what we get.
The Department of Justice under Jeff Sessions reversing its position on Texas's controversial voter ID law after siding with civil and voting rights organizations for the past 6 years. Well, the Obama Department of Justice did, not Jeff Sessions. Today, DOJ lawyers plan to inform a federal district court in Texas that the government is abandoning its argument that the law was designed with the intent to discriminate against blacks and other minorities. Although the law was enacted in 2011, a federal appeals court blocked its full implementation during last year's presidential election after ruling that the law had a discriminatory effect. But the appeals court left the question of whether the law was intended to discriminate against minority voters to the lower district court. The bottom line is that this is the first major voting rights case for the Justice Department under Jeff Sessions. And the DOJ is no longer fighting laws that violate the Voting Rights Act. Joining us to break this all down, Danielle Lang, Deputy Director of Voting Right for the Campaign Legal Center, one of the organizations fighting the Texas voter ID law in court. So here we have Jeff Sessions, who was held up as the beacon of light when it came to civil rights, as somebody who advanced and protected the rights of voters in Alabama, which we all knew was a lie when it came out of his mouth. And here's one of his first actions when it comes to the discriminatory Texas voter ID law.
Absolutely. And I think that you make a really good point, which is that, yes, he was held up as a beacon of civil rights, but at the same time, every single major civil rights organization was warning Congress that this was unacceptable. So while it's true that the Trump administration tried to hold him out as a civil rights beacon, we all knew that wasn't true. And in fact, the director of voting rights at Campaign Legal Center was at the Department of Justice when Jeff Sessions was there, and he was the one working on the cases that Jeff Sessions listed on his questionnaire as civil rights cases that he worked on. And he introduced testimony in front of the Senate Judiciary Committee saying these were not Jeff Sessions cases. Jeff Sessions did not work on these cases, so we knew what was coming. That being said, after 6 years, almost 6 years of the Department of Justice saying that this law on the facts was intended to discriminate against minority voters, put away what actually happened, which was a huge discriminatory effect, that it was intended to do so. No facts have changed, and yet the Department of Justice is going to stand in front of a federal district court judge today and say they're dismissing their claim, giving up the claim.
Giano, thoughts?
Well, my thoughts are, in this particular situation, and this, from my view, I do believe that there was maybe not an intent, because I don't know what the intent was to discriminate, but when I look at areas where you have to drive 100 miles away to get an ID, I know that there is a level that discriminates against individuals. That I get. I'm not saying there's an intention there.
But putting that in the law was intentional. And the root word intentional is intent.
But that does not mean that they said per the law you got to drive 100 miles away. That says that there wasn't enough resources allocated for people to get ID.
I'm sorry. Go ahead.
They were informed that this was the case. There were legislators in the debates saying, Wendy Davis explaining that this would harm minorities, that minorities would not be able to get IDs. They had numerous amendments. So part of the case and part of what the courts have relied on to find it, the district court relied on was that.
What we're saying is we find some agreement where I'm saying it's inappropriate. They should have provided resources so folks wouldn't have to drive 100 miles away to get an ID. So yes, that will disenfranchise people. I get that 100%. Another element of the case, which was the ID part. So people had a problem with the fact that students could not use their student ID to vote, which I find to be problematic on many levels, because they use an example of you can use your gun license to vote, but you can't use your student ID. Well, we know that with your student ID, there could be a student that's actually printing the ID. The student IDs can be manipulated, and gun registrations are issued by the state. So there's different.
Can you please?
Okay. He was smart. He got away from her argument on intent because he didn't have a defense on that. But two, he should have never jumped into the student ID part in Texas, because obviously he's not from Texas. The state of Texas issues an official student ID when you go to obviously the state universities or any college or university that is specifically controlled by the state of Texas. The damn thing is laminated to prevent duplication. There's a barcode on it. There's all kinds of protective measures on state student issued IDs. He wasn't aware of it. Bad position, and he needed to eject, but unfortunately he didn't.
I am from Texas.
Right.
I am born and raised in Texas.
Right.
The law in Texas was you could not even use a state issued ID from a state university. You can't sit here and print an ID from Texas A&M. Do you know why? There's a barcode on the back. It's state issued ID.
So
Texas
A&M
University is a state university.
So you're saying it can't be manipulated?
Well, guess what? Would that be the logic? A driver's license can be manipulated.
Driver license can be manipulated, but not in the same way in which a college ID.
You clearly.
Oh God! See, a state-issued ID is a state-issued ID. You can, if he wants to make that argument, you can manipulate a concealed carry license, which is also state-issued. You can manipulate anything. Hell, you could manipulate federal government-issued IDs. Bad argument.
know the IDs used in Texas. I do because I had one.
Okay, that's
Go ahead. I'm sorry. Go
No,
ahead.
that's quite all right. But so to point out that it was on the record that legislators said that they had absolutely no reason to believe that student IDs were being used in a fraudulent manner to vote. So the question is, what evidence was before the legislators, and the legislators could not explain why they rejected amendment after amendment that Wendy Davis and other legislators said would help minorities, and they rejected every single one. And on that record, the district court found discriminatory intent, and that issue is once again before the district court, and unfortunately the Department of Justice is not interested anymore.
Monique.
Right, and the thing that to me is critical here is that sometimes people don't know that the threshold is necessary. It's not just enough to show that there's discriminatory effect. We have to go the next step and show that that was the intent, and we look at the legislative history as she just finished saying. But what we have to do now, organizations like yours, like an AACP Legal Defense Fund, look folks, they need money, they need support, because this case doesn't disappear when our federal government drops us. There are still other organizations who are bringing suits on behalf of people of color, and we need to support those organizations and the lawyers that are doing that work.
Danielle, we appreciate it. Thank you so very much.
Thank you very much for having me.
All right, thanks a bunch.
Yeah, so like I said, the reign of Jefferson Beauregard Sessions has begun, and by the time his reign is over, I just hope that there are some of us left standing.